everyone, welcome to Topic of the Day. In this edition, we will be discussing the Anti-defection Law. Now, this is in context of the recent statement by our Vice President, Sri Venkaiah Naidu, who said that it is time for amending the Anti-defection Law to plug the loopholes. Now, let's discuss what is the Anti-defection Law and its purpose. The Anti-defection Law was introduced as the 10th schedule via the 52nd Amendment Act 1985, that was back during the Rajiv Gandhi government, after multiple incidents like Aaya Ram Gaya Ram. Now, this statement Aaya Ram Gaya Ram originated when an MLA from Haryana named Kaya Lal changed his party thrice in 15 days. So, this so-called meme refers to the horse trading of MPs and MLAs. Now, this law sets the provision for disqualification of elected members on the grounds of defection to another political party. It also includes situations in which an independent MLA too joins a party after the election. So, what is the purpose of this law? It is to bring stability to the governments by discouraging the legislators from changing parties, and also to ensure that the party ideologies prevail over the individual interests. Now, let us understand what constitutes defection. This law covers three kinds of scenarios as grounds for qualification. The very first is legislators elected on the ticket of one political party when voluntarily give up the membership of that party or vote in the legislature against the party's wishes. Secondly, when an MP or an MLA who has been elected as an independent joins a party later on. Now, in this, the nominated legislators can join a political party within 6 months of being appointed to the House and not after such time. Now, as per the 1985 Act, that was the original Act, a defection by 1/3 of the elected members of a political party was considered as a merger. But the 91st Constitutional Amendment Act in 2003 during the Atal Bihari Vajpayee government changed this particular order. So now at least 2/3 of the members of a party have to be in favor of the merger for it to have a validity in the eyes of the law. So who is the deciding authority in this scenario? The presiding officers of the legislature, that is the speaker or the chairman. And also the MPs or MLAs can challenge their decisions before the higher judiciary. Now let us discuss certain key controversies or the issues surrounding defection laws. Firstly, no time frame is provided for a presiding officer to decide in the law. The court has held that ideally speakers should take a decision on a defection petition within 3 months. Secondly, the lost individualism of MLAs and MPs. The anti-defection law punishes individual MPs, MLAs for leaving one party, but it allows a group of MPs or MLAs, that is 2/3 of the elected, to join the party. Thirdly, there is no onus on accepting parties. That is, it does not penalize the political parties for encouraging or accepting the defecting legislators. In addition, it has also failed to ensure the stability of the government. Now, let us discuss some of the suggestions to improve the law. Firstly, the Election Commission has suggested it should be the deciding authority in defection cases. And secondly, the Supreme Court has suggested the Parliament to set up an independent tribunal headed by a retired judge of the higher judiciary. Now, let us take up a practice question on this topic. Which of the following schedules of the Constitution of India contains the provisions regarding anti-defection? A. The 2nd schedule, the 5th schedule, 8th schedule, or D. The 10th schedule? You can write your answers in the comment section below. So the correct answer is D. The 10th schedule contains the provisions regarding the anti-defection law. Well, that's a wrap of today's edition of Topic of the Day. For regular updates, you can follow us on our social media handles, and for more such videos, do stay tuned to the next IAS YouTube channel.